I'm Wesley Hottot.
Okay.
I'm a senior attorney with the Institute for Justice.
So explain why. Explain if you win the if the court were to say yes, we're going to incorporate this to the states. That can mean a great deal, and it can mean really nothing, as Justice Kagan pointed out. You can, if they don't allow some sort of proportionality evaluation, you, you could be very hard pressed to fight most forfeitures, wouldn't you?
Well, it's possible. It's also possible that lower courts will continue to develop the tests that they're applying today, and that some forfeitures will be found unconstitutional, just like they have been. There are dozens of federal cases where forfeitures have been struck down under exactly the theory that we're advancing here. But this case is about more than just a truck, and it's about more than just a forfeiture. It's about whether all Americans enjoy the protections of the Bill of Rights. And all we're asking the court to recognize is that every American has the protection of the excessive fines clause.
Mr. Timbs, could I get you to come up here?
Okay.
I'll even put my arm around if you want to warm you up. You said to me when we talked before that that the truck, losing the truck has cost you more than money, and that you're very lucky you have your Aunt Wendy. Can you explain?
Well, since the beginning, she's been there for me. I use her car. I lived in her house when I first moved here. She was just somebody in my position when I was going through that. The main thing for me was I just needed somebody there. Where the life I was living, that's not something we're used to, is having people there for us.
So you have a job as a machinist?
Yes.
And how far away is it?
About 35 minutes.
And you use her car to get there, right?
Yes.
So what does she do?
She either doesn't drive or she takes the bus to dialysis 3 days a week. The city bus comes and picks her up, and then it brings her home because I have her car at work.
So this truck, explain what it meant to you when, it's 5 years now, right, since the truck was seized.
Mm-hmm.
So it cost $42,000, but once you had gotten clean, it meant a great deal to you. How?
It wasn't just a truck. To me, at that point, it became a social issue. Almost to me, it was a symbol, of in my opinion, the wrongs that, just one of the wrongs that are the crime that I'm having trouble talking.
Sorry. Well, let me put the question this way. What did it cost you in terms of your ability to move around? What couldn't you do easily?
Oh, there are a lot of things. Counseling appointments, even going to NA and AA meetings. I had to get rides or walk. Self-esteem, it still affects my self-esteem. I'm a 37-year-old grown man, and I don't have my own vehicle. At least, well, I do, but I don't have access to it.
So when you get it back, you bought it for $42,000 in 2012. It got taken from you the night or the day you were arrested. What is it worth now? Do you have any idea?
You'd have to ask Kelly Blue Book that. I have no idea. I assume much less than what I paid for it.
Mr. Hottot, what are the numbers for civil forfeiture in the country?
Civil forfeiture is one of the greatest threats to property rights in the country today, and this practice has exploded just over the last 20 years. We looked at 12 states where there was $257 million in forfeiture proceeds, I believe in just the last 10 years. Is that right? And the federal government is the biggest abuser of the forfeiture laws. The federal government got forfeiture started in the 1980s during the drug war, and ever since, everyday Americans, some not even charged with crimes, have had their property seized and forfeited to the government. Most concerningly, 100% of the proceeds under federal law go to the seizing agency, and that is a dangerous profit incentive for them to forfeit ever more property.
But the bill of the excessive fines clause does apply to the federal government. It hasn't helped so far. Would this case help you in federal cases?
Well, I think the excessive fines clause has helped. As I mentioned, there are more than a dozen federal cases in which judges have determined that the forfeiture would be excessive under the clause. Now, almost by definition, most forfeitures aren't excessive, and nothing about our argument would prevent the government from seeking serious fines for serious crimes. All we're saying is that all Americans have the right to invoke the Bill of Rights when the government tries to take their property from them. This case is about property rights, and it's about the Bill of Rights.
And we hope, I'm Scott Bullock, I'm President General Counsel of the Institute for Justice. Hi. And we hope this is the first in a series of cases that the court takes on to fundamentally reassess the constitutionality of civil forfeiture. Justice Clarence Thomas issued a statement in another case earlier this year saying it was time for the court to do that. We hope that this is the first step toward the court doing that. There seemed to be some interest by certain justices in making sure that civil forfeiture, modern civil forfeiture laws comport with the guarantees of the Bill of Rights, and we hope that this case is the first one in a series that the court takes on.
Mr. Bullock, this is a rare case in the sense that there are friends of the court on your side from right to left. Everything from the Chamber of Commerce on one side to the Southern Center on Poverty, to the NAACP, so why is that, do you think?
Well, this is an issue, you're absolutely right, that unites people from across the political spectrum. And I think it gets to a deep-seated sense that this is just fundamentally wrong. I mean, people can't believe that in America the government can take your property regardless of whether you've been convicted or even charged with a crime. And so that's why so many people from left, right, anywhere in between agree that civil forfeiture is being abused and it has to be stopped, and at the very least constitutional limits have to be applicable to it. So we were very proud of the breadth of support we had from so many different groups that usually don't see eye to eye on many constitutional issues.
You know, Justice Breyer raised the proportionality question, and several other justices sort of said this is like I'm not sure, I'm missing a word here from my brain, my cold brain. It's sort of like the minute you say proportionality in terms of punishment, it's like putting a cross up in front of the vampire. No, we're not going there. So how are you going to get there?
Well, I think on this case, all they have to do is decide that it is incorporated. And then the lower courts will apply it. They'll develop tests, which have already been developed in other cases in the federal appellate courts and even in some earlier Supreme Court decisions. And then if the court thinks that this is getting out of control, perhaps too many forfeitures are being struck down, or it's starting to impact other decisions that affect punishment, then the court will step in. But I don't think it seems, and we're cautiously optimistic that the court is not going to just throw up its hands and say, this is not incorporated at all, and that state and local governments have free rein to impose whatever forfeitures they want. And I think that's where several members of the court were concerned when the state conceded that it didn't matter, regardless of what vehicle it was, if the government wanted to forfeit it, it could do so.
Thank you.
In your briefing, you talk about Indiana as an example of particularly bad practices in the country. Can you talk about that position?
Yeah. Unlike any other state in the nation, Indiana allows local prosecutors to outsource forfeiture proceedings to private individuals, private lawyers, working on contingency. So this case, Tyson's case, was brought by a private law